I'm not threatening you. Say one more word and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are knocking on the door of number 218 in our compilation list. And as always, I appreciate you guys for joining me here for this compilation. We will be in 4 different judges' courtrooms on today, all female judges, by the way. And I'm sure you guys are going to be looking forward to how these judges handled their sovereign citizen situations. Before we get into that, don't forget, commentary will be left in from when they previously aired. Also, chapters will be added for your convenience. And don't forget to like, comment, share, and subscribe. It is much appreciated. Now, the 4 judges' courtrooms we will be in on today. First, we will be in the courtroom of Judge Meegan Miloud out of the state of Colorado. Second, we will be in the courtroom of Judge Kristen Simmons out of the state of Michigan. Third, we will be in the courtroom of Judge Victoria Shackelford, also out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Erane Washington, also out of the state of Michigan. As always, it is a pleasure to bring you this compilation. It's time for me to get out of the way, and let's check out 218.
All right. Court is calling People versus Brendan Troutman in 25 CR 2239. If I can have appearances.
Holly speaks for the people.
And Brendan Troutman in proprio persona, all rights reserved.
All right. Ms. Troutman, last time we were here, you had informed the court you were still seeking counsel and you did not get the application for public defender's office even after the record was made, if there was any changes to your finances. So how are you proceeding today?
Well, I'm forced to be going to trial on this, I guess, if this is the last arraignment. I do not have the funds to secure private counsel.
For the record, did you inquire the public defender's office again after your last arraignment?
Yes, my income hasn't changed. I've moved my budget around to accommodate a small savings amount to secure a private attorney. But yeah, so I'm getting retainer fees of $2,500, $5,000, and $15,000. So that's
Okay,
just
so
not...
just for my clarification, you still don't qualify for the public defender's office?
No, I do
Is that what
not.
you're letting me know. Okay.
Yes.
All right. Ms. Spies, any additional record for the people?
Judge, I believe at this point, Ms. Troutman and I have had a phone conversation, a few conversations before court on different dates. And so given that I believe we've given ample opportunity to apply for the public defender, we should proceed forward with setting trial dates. I did just want to make a Lafleur record, and I don't have in my notes that an Arguello advisement was done, so I'm not sure how this court would like that.
I advised her last hearing, Ms. Spies, I believe Ms. Davis was covering for you.
Thank you for letting me know. In terms of the Lafleur record, right now, as the charges currently stand, the defendant has been charged with 5 counts. Count 1 is F for assault in the second degree strangulation, and count 2 is F for kidnapping, seize, carry. Count 3 and 4 and 5 are all misdemeanor counts. Count 3 is assault in the third degree, and count 4 and 5 are misdemeanor 1 or child abuse, and count 5 is misdemeanor 2, child abuse. I met with Ms. Troutman in the disposition room before court today and inquired if she wanted an offer. She said no, she did not want an offer and she would proceed to trial. Given that, I just wanted to put on the record that if Ms. Troutman wanted an offer, what we have VRA compliance for is M1 assault in the third degree and M1 child abuse for a dismissal of all felony counts and the remaining misdemeanor count with an agreement to probation.
Thank you for that. Do you understand that that would be the offer if you were interested in hearing an offer from the district attorney's office, Ms. Troutman?
Yes, I heard what she said. And I do get that that would be the offer she would be extending to me should I choose.
Okay. And are you accepting that offer today?
No, I am not.
We will set this for a pretrial conference. I'm going to set this on my next docket day of May 26th. Ms. Spies, is that clear for you?
May I have one moment, Your Honor?
Sure.
I also have two things that I need to put on the record.
Okay, hold on
This
just a
one.
moment.
Did you say May, Your Honor? Or
I did. In 2 weeks?
May 26th.
Mhm.
Yes, I can accept that.
Okay. All right, that's in 2 weeks. Ms. Troutman, morning or afternoon?
Afternoon will work. You're saying, is this pretrial? What is this?
Pretrial conference is when you clear dates for motions, hearing, and a jury trial.
Okay.
Speedy trial will run from today as I have entered a not guilty plea on your behalf. Speedy trial 6 months. We will set motions, jury trial, as well as a plea cutoff within that time.
So I do want to put for the record, I have to request an ADA advocate for this because I am not formally trained in law. That puts me at a huge disability with moving forward with this case. Secondly, am I allowed to put what I need to put on the record right now? Or do you want me to wait?
Go ahead.
Okay, I just want to draw attention to my notice of intent for seeking redress, my right to redress, actually. For the record, God-given right for motherhood was violated, amendment violations, compelled being a witness against myself, clear evidence of investigation practices operating from a presumption of guilt, abusive process, judicial misconduct, prosecutorial misconduct, trespass, assault, and batter, and wrongful imprisonment. And I will be seeking redress in accordance with the Supreme Court ruling Trezevant versus City of Tampa and the fee schedule that is currently on record with the Denver County Clerk of Record. In accordance with 42 USC 1983, 18 USC 241, and 18 USC 242. Notice is given.
All right, pre-trial is set in 2 weeks. You're indicating afternoon setting. I can do a 2:30 if that clears with Ms. Spies.
Judge, I am in a motions and status conference at 1 o'clock in Division 500. We've already had a motions hearing, so I don't think it would take too long. But I fear if it goes past an hour and a half, then I may make this court late.
How about I do an 11 a.m.? Can you do an 11 a.m.?
11, yeah, that would work.
I can accept that. Thank
Okay.
you.
All right, Ms. Troutman, I will see you back on May 26th in this courtroom at 11 a.m. for a pretrial conference. The parties I do provide dates for jury trials and motions if you can clear that before I call the case.
Yes, Judge.
All right,
Okay.
we'll be in recess.
Thank you.
City of Lansing versus Erane Skates, 25-01554. Parents, please.
Judge Meegan on behalf of the City of Lansing, Your Honor.
You are Erane Skates? Okay, today was the date that was scheduled for hearing. I have a hinder and obstruct the polls, pretrial, and a furnishing false information. Did you all discuss this matter and how do you want to proceed?
Your Honor, if I may, Mr. Waddell did speak with Mr. Skates before we were on the record here today, and Mr. Skates indicated that he had submitted some documents to the court, and we did not receive any documents from you.
There's been no motions filed with the court. There are some documents in the file, but that's not a properly filed motion according to the Michigan court rules, so the court does not have jurisdiction to review those.
Yeah, at this point, there was no offer made. We were giving him the opportunity to present us with some sort of documentation, but at this point, we have no motion.
Okay, they're not offering a reduction in the charge. You have the right to proceed to a trial. You have the right to jury trial. I think you declined court-appointed counsel and said you would retain an attorney. Is that accurate?
I was talking to one, but it's not really in my means to acquire the attorney.
Okay, so would you like to maintain your not guilty plea and proceed to trial, sir?
I don't consent to anything here. I can't look, constitutional rights were violated, so I am on the record. My status is a Moor American national. I am not a Black person. I am not a United States citizen, so that's why I claim my nationality as a Moor
You don't have to be a United States citizen to be charged with a crime in the United States. I know if I were you, I wouldn't go around here in open court live stream declaring that I'm not a United States citizen facing criminal action with the current federal administration. That was not in your best interest. I wouldn't do
I
that.
can't claim my national status on the record.
Yeah, okay, that's fine, but you are making a declaration that you're not a citizen. And we have an administration that is making efforts to make sure people who are not citizens, who are facing criminal actions, are deported.
So when I'm claiming my national status on the record, it's for this land here.
I recognize that. This land here is known as the United States of America. This court sits in the city of Lansing, Ingham County, state of Michigan.
United States is a federal
Okay.
corporation though.
Okay.
So when I claim,
Wonderful.
I'm not.
If you want to
maintain.
if you want to stand mute, you have the right to do that. You have the right to plead guilty or plead not guilty. I recognize that you're asserting yourself as a sovereign citizen.
No, not sovereign citizen.
What are you
Said
saying?
just sovereign. Don't, it's confused. It's a misnomer to say sovereign citizen.
What you're asserting yourself as what?
Just sovereign on the land.
Okay.
of American indigenous
Okay.
to the land.
I'm happy to hear that you're sovereign and indigenous to the land. The court will continue your not guilty plea. This matter will continue to trial, okay?
Can I get some type of documentation?
We're gonna give you the notice to appear for a jury trial. September 2nd at 8:15. September 2nd at 8:15 in person at the court, okay?
Okay. And
You need to wear a shirt that has sleeves.
I just came to work, so.
I recognize that, but I'm talking about for your jury trial. You're gonna need to be appropriately dressed, okay?
This isn't.
It is not. And I'm advising you of this on the record so that you know to come appropriately dressed for your trial. Okay? Thank you. Do you have any questions for the court at this time? Any additional matters for the record?
Nothing from the city, Your Honor.
Thank you. We'll get your notice to appear. You're all set.
Let's get that in jail or?
No, we're gonna get to you right now.
Okay.
All right, this is 2301405 JP Morgan Chase Bank versus Arnold Chavez appearances.
Yes, Your Honor. Christopher Royce, P49102 on behalf of plaintiff.
All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez Arnold.
There you go. All right, so last time we were here, the parties appeared and I gave 10 days to submit answers to interrogatories. Were the answers to interrogatories filled out and returned?
Well, Your Honor, they were prepared. When I prepared for the hearing, apparently they were not sent. I did email them to Mr. Chavez this morning. However, the document production requests were, all documents were produced within days of the hearing, Your Honor.
All right, so Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just said, I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Mr. Royce, when were they sent?
They were sent on August 30th. Make sure that I'm.
No, we had a hearing on, maybe I have that on 10/24. We were waiting for answers to interrogatories.
Yeah, the interrogatories mostly related to whether there's compliance with the UCC and transfer of a note, and whether there was an assignment of debt, which of course there was not here.
Were all the documents submitted?
All documents, except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statements were provided.
Okay. So Mr. Chavez, what is the defense on this case? What is your defense?
Well, I needed to see one of the documents. Well, my defense is that, you know, I've been researching the law and, you know, the powers of the banks. And it's more of a accuracy of the actual accounting that I'm trying to make sure, and make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, I mean, back on 5/15/23, you owe $3,398.36. And they're coming for $3,398.36. I mean, that was the balance on the card at that time.
Like, that's why I asked questions, Your Honor. You say you gave them 10 days to send it to me. They didn't send it to me. I just got an email
Mr.
this morning.
Chavez, you're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No, it is the issue at hand. The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those are the questions.
Okay, my defense is I am the lender and they borrowed from me.
What did they borrow from you?
My personal security, which I'm
No,
entitled to rights to.
no, I'm not buying that. No. Listen to me. Listen.
It's not about, I'm going by the law, Your Honor. I'm not just making up
No,
anything.
you're not going by the law. You're making up the law as you go along. You took a credit card on. You agreed with that. And then you had a credit card. You used the credit card. You have a balance on the card and you didn't pay on the card. They don't owe you anything.
So when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Mr. Royce, I don't have a motion for summary disposition in the file.
Yeah, we talked about that last time and I was going to file one, but this hearing was a little bit too early. The motion would have had been filed the next day. So I did not get that out.
All right, motion for summary disposition. We will have a hearing for a summary disposition on December 19th. Can I see that? 1 second. One second here. I have them.
No, wait a minute. December 19th.
Okay. It's gonna have to be January 9th.
Okay.
My clerk's indicating.
I will get that out right away. I had it prepared, but then I noticed that I didn't have enough time to actually serve it.
Yeah, motion for summary disposition, hearing date will be January 9th at 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
All right, we're all set. All right, and I've got Mr. Chavez back. Do I have Discover Bank still?
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674. The Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992, of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed. And then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet and it was working in my area. I have proof of, I talked to them in the chat. They confirmed it. And I have they gave me a bill credit for the inconvenience. So that's why I wasn't able to attend, because I was having problems with my internet.
All right, and just so you know, Mr. Gopal, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
I just want to go through the due process.
Okay. All right. Here's what we're going to do. I'm setting a date. So what do we need discovery on this? What, Mr. Gothal, so this is a credit card bill?
Yes, Your Honor, a Discover card.
All right, and this is Discover Bank, so there's no issue as to whether or not it's transferred hands?
No, Your Honor, we represent the original creditor.
All right, and I see there's an answer file. All right, this is an account stated under MCR 2.116, parent I. This court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's an account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29. Under MCR 2.116, parent I, parent 1, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay, and the court is doing so.
Well, I have affidavits that support what I'm saying, but I will want to enter into this as evidence.
The motion for summary disposition is granted sua sponte by this court. There is no valid defense to this claim, and
I couldn't even enter any evidence.
And a judgment in the amount of what is claimed in the complaint, $4,378.29, will be entered by this court, and documents can be submitted for that purpose. And officer, I have a few more documents for that, and we're all set. All right, we're all set. Thank you, Mr. Arnold. Mr. Arnold, I have ruled against you. I am allowed to do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done. Thank you.
Thank you, Your Honor.
Well, guys, we have come to the end of these two proceedings. And as we can see, Mr. Chavez, his first appearance in Judge Shackelford's courtroom, it ended up getting a continuance for that Chase a credit card that he owes money on. I believe it was about $3,400. And shouts out to Judge Shackelford for what she said to him, because even though he came up with all these different defenses, one thing I respect, she said, listen, did you apply for that card? Did you receive that card? Did you use that card? And did you pay back the balance? If the answer is no, then guess what? You owe money for the money that you spent on the card, for the usage that you put on the card. And obviously he comes back, with that outrageous statement of, I didn't borrow from them. They actually borrowed from me. I'm actually the lender, which speaks to one of the biggest things that I'm about on this channel, which speaks to accountability. And I think that's what we find in most of these court cases, especially the sovereign citizen cases, is people just don't want to deal with accountability. And that's the same goes here for this young man, because not only does he owe on the Chase card, he owes about $4,400 on the Discover card. And it's like, bro, if you spent this money, you owe it. Either make a decision, don't pay it or pay it. But to try to get out of it with different, bogus claims. And as we can see in the second appearance, it didn't get a continuance because she basically ruled in favor of the creditor, because she said, everything that he submitted, it didn't dispute what they were saying. Like, he didn't come up with anything valid to prove his case. So we'll be following behind this case. He'll be going back in January 9th. But it's going to be the same thing. He doesn't want to be held accountable for what he owes. But hey, you spent the money, you owe it. That's life for all of us, right? I mean, some of us got credit cards that we may use, and guess what? It don't feel good to, pay it back, and unless you're somebody that understands that process and you're willing to be accountable and say, listen, it is what it is. I spent it, I owed it. But that's just what it is, right? Like, if you're going to use it, you got to pay it back. You got to be accountable for your actions. But I don't want to just keep going on and on. I just wanted to say that, like, let's be accountable to our actions, because if we don't hold ourselves accountable, what we normally find is we'll continue to repeat those behaviors. All right. With that being said, guys, this is Sovereign Citizens Hall of Fame. I am your boy TP. And until the next time, Sovereign Citizens Court is adjourned. God bless, guys. Peace.
All right, the court will call the matter of the Township of Ypsilanti versus Shannon Phillips, 24W001656.
Paul Barnett on behalf of the township.
Assistant Public Defender Davi Lieb on behalf of Ms. Philp. Your Honor, when I speak to Ms. Philp yesterday, she advised me that she did not want to be represented by the Public Defender's Office. Ms. Philp, could you say your name, ma'am?
Ms. Phillips, please state your name.
Yes. Shannon Phillips, the natural woman. On the record and for the record, and let the record reflect. Can you guys hear me? It's saying I have an unstable connection. Okay. Just making sure.
So on October 9th, defendant was found in contempt of court. So that still stands, ma'am. You can choose not to have counsel if you want, but you need to understand that you can get up to 90 days on the contempt of court matter. Do you understand that?
I do not understand any charges. I only understand universal law and the right to live in peace and to live as I intend to.
But given that she doesn't understand,
was never let in, just like now. But I obviously, I guess it took a minute. you administering the trust without consent?
I'm not going to be.
I'm having a bad connection. It's going in
I'm
and out.
not
I'm
going to
not
be
hearing nothing you
releasing the
all are
public
saying.
defender's office from this case because I don't think she fully understands the consequences of her actions, and so she will continue to have the public defender.
I don't
Thank you,
need a public defender, Judge Washington.
Ma'am, I asked you a simple question and you did not answer the question in a way that makes me feel comfortable that you don't understand that you understand the laws of the state.
You all are speaking legalese. You all are speaking legalese. For me to say I understand the charges gives you all permission to administer the trust.
Okay.
I don't understand the charges.
Which is why you will not.
And I do not need counsel. I don't need representation.
Your request is denied, ma'am. You will have representation. All right. Mr. Lebo, do you know what your client wants to do?
Oh my goodness. This is
the charges.
You cannot make me have an attorney.
Well, actually I can, ma'am.
Like, this is insane.
Well, I don't think it's me that's being insane.
I can handle my own affairs. I don't need your public defender. All I'm trying to do is get the case settled. That's all. This has been going on for so long. A waste of time and money, honestly.
Mr. Barnett, is there an offer?
There is an offer for the civil infraction and expired plate.
Your Honor, I'd be happy to go into a break-in with Ms. Phillips and explain that to her.
Okay, I will let you do that.
Thank you, Your Honor.
You're welcome.
Traffic infractions are not a crime.
What will we call the matter of Ypsilanti Township versus Shannon Phillips, case number 24W001656.
Paul Barnett on behalf of the township.
Assistant Public Defender Davi Lieb on behalf of Ms. Phillips. Ms. Phillips, could you unmute and state your name, ma'am?
You have to unmute, ma'am.
Shannon Phillips, the natural woman.
Lebo, where are we with this, please?
Your Honor, I did have a discussion with Ms. Phillips. I did attempt to explain the importance of representation, why the court has asked that she have an attorney in this matter, as well as conveyed Mr. Barnett's offer. Ms. Phillips indicated to me that she still opposes having an attorney, additionally indicated to me that she is not at this time wanting to accept the offer of an expired plate.
Well, I think the offer was for a civil infraction of something different.
I believe was the civil plate infraction.
Oh, I see. Okay. All right.
It's improper plate.
What was the offer again, Mr. Barnett?
It was the civil infraction of having an expired plate.
All right, thank you. And not the criminal, not the criminal infraction. Okay. So, Ms. Phillips, that's correct. You're rejecting that offer.
The offer of what? He didn't offer anything.
Ms. Phillips, he just told you that he's offering.
Am I not hearing something?
He just told you that he's offering you the civil infraction of expired plate as opposed to the criminal offense of expired plate. One carries
okay, but according to the Supreme Court, traffic infractions are not a crime. The People versus Battle. So what criminal infraction? And I would just like for the case to be dismissed. One, because your who was it, Officer Hannah, and 3 more officers were surrounding my vehicle, pulling my door handles, threatening to pull me out of my vehicle.
Ms. Phillips, I'm going to advise
I
that
don't
you
even
not
have the
discuss this
vehicle
further.
anymore.
Ms. Phillips, I'll take that as a rejection of the offer. What
Okay,
is your
so what's
client
the
up
offer?
to? I'm
I
not
didn't
gonna
tell
keep
him
going in
anything.
circles with you, ma'am. Mr. Lebo?
Right, y'all just hate to hear the truth. Y'all just want to do what y'all want to do.
Ma'am, if you don't stop yelling out in court, you've already been held in contempt before. I'm gonna hold you in contempt and give you 10 days in jail. Do you understand? Mr. Lebo, do you know what your client would want to do?
I do not, Your Honor. I did have a discussion with her, but she did not convey to me a desire to participate in that conversation.
All right. Then if she's not telling you, I will set it for a trial date.
Ms. Phillips, Your Honor, I would perhaps ask the court to consider a competency referral.
Nothing is wrong with me, you all. I am perfectly fine. I can handle my own affairs. Nothing is wrong with me.
I see you're doing so well so far. You're almost going to jail on a traffic offense.
And I do want to know that I did attempt to explain to Ms. Phillips why her understanding of the case law regarding traffic offenses was inaccurate, but that was not a productive conversation.
I could see why it wasn't productive. So I don't know that she meets the level of incompetence to the standard that you're indicating, that if you want a referral because you've talked to her and that's where you are, I will refer her for a competency. If she doesn't participate in that, then she'll be found in contempt or have to go to jail to get it done. So her behavior here today is obviously taking her down a very dark path. Hopefully she can change her mind and do something appropriate. So you either want to have a trial, ma'am, or you want to actually accept an offer. So those are your options.
We could take it to trial. We could take it to trial. We could take it to trial. We could take it to trial.
I heard you when you said it the second time.
Okay, well my screen is saying bad connection, so I'm not sure.
Your Honor, perhaps we could adjourn this pretrial and I couldn't attempt to discuss with Ms. Phillips a little bit further in the interim time.
All right, because if she goes to trial and she's unsuccessful, it would be treated like any other criminal matter. So, ma'am, you do understand that you could get up to 90 days in the Washington County Jail, correct?
I hear you.
Retrial will be adjourned to January 8th, 2025 at 10 o'clock a.m. I'm sorry, 9 a.m. Do you have her contact information so you can talk to her so she fully gets what's going on here?
I do, Your Honor, and I would just ask the court if the court could repeat the pretrial date.
I'm sorry, repeat it. January 8th at 9
Thank you, Your Honor.
a.m. Ms. Phillips, we'll see you back here on that date, ma'am.
Well, guys, we have come to the end of our courtroom proceeding. And all I can do is just say, wow. I mean, first time in Judge Washington's courtroom, she definitely was not having it. When Shannon Phillips introduced herself and said, Shannon Phillips, the natural woman, and the way Miss Judge Washington rolled her eyes, I said, oh yeah, this is going to be a long one for Miss Phillips. And definitely Judge Washington wasn't having it, made her keep her public defender. I've never seen that before. Maybe you guys have. Made her keep her public defender. And it seems like Miss Phillips had never seen it before either by her reaction. But Judge Washington was super annoyed by this proceeding. We see Miss Phillips try to bring up the officer thing again. And if you don't know what I'm talking about, that means that she didn't watch the first one, but she tried to bring up what the officers did to her again, but they quickly blew that off. Then the public defender asking for the competency hearing. And then you hear, Miss Phillips starts yelling out, oh, I'm fine. Nothing's wrong with me. And then you hear Judge Washington's response. Yeah, you're doing well so far, to the point of where you've almost gotten yourself arrested over just a traffic offense. So definitely was a lot going on there. But once again, Judge Washington wasn't having it. This thing has been set for trial, and we will be following it and trying to make sure we get you that trial hearing. But listen, guys, I always appreciate you guys sitting in on these videos. Thank you so much for all the subscriptions, all the love, the comments, just everything that you guys do, the super thanks, just everything that you guys been doing. I just want to say I appreciate it very much. With that being said, this is Sovereign Citizens Hall of Fame. I look forward to catching you guys on the next one. And with that being said, court is adjourned.
I'm not threatening you. Say one more word and that's 30 days. 30 days.